was adjourned, but my lord, this matter is coming on the 22nd. My only prayer today is, my lord, let this matter be finally heard. Let this matter be decided, my lord. This order may not be given effect to, my lord. The order passed by the trial court. The order may be kept in abeyance, my lord, till such date.
Please, Your Lord. So I'm seriously opposing this application. Firstly, my lords, the petitioner is guilty of suppression of very important facts. If Lordship will turn to the order sheet of this particular court, please have the order dated 2/7/24.
Which?
Well, it's not part of their application. They've suppressed these facts. This is part of the order sheet.
I'm only praying for a very short accommodation, my lord. No question of suppressing any facts.
Just kindly have this.
Yes.
So when this matter was originally moved, this was the order that was passed. My lords have it. The matter has been fixed today for admission hearing. So and so, counsel so and so, learned counsel for the petitioner, however, sought time due to personal difficulty. Learned counsel for the respondent has apprised the court that execution case has been fixed today for hearing. It is made clear that pendency of the revision application before this court shall not be a bar for the executing court to take up the hearing. Prayer was made for a stay. It was not entertained by the court. The next order, my lord, is an order dated 9/5/25, passed by your lordships. Miss So-and-so, learned counsel for the petitioner, has once again sought for accommodation in this matter as the conducting counsel is indisposed on grounds of personal difficulty. Learned counsel for the respondent, though not objecting to the prayer made, has pointed out that the matter involved here involves execution proceedings pending before the trial court. The learned counsel would also admit that there is a direction of the Honorable Supreme Court as far as disposal of execution proceedings are concerned, wherein the timeline has been fixed at 6 months from the date of initiation of the same. In this regard, this Honorable Court has also issued relevant notification bringing the same to the notice of the trial courts within this High Court. This being the case, though there is no interim order passed in the instant petition, the learned counsel for the respondent submits that the proceedings before the trial court should not be stalled in view of these proceedings before this court. Needless to say, it is expected that the case before the trial court should proceed in accordance with law and procedure in absence of any direct order or suitable direction by a superior court, including this court. Therefore, under such circumstances, the trial court is at liberty to take its own course of action. And my lords will see the last order. This is the order possibly that they are relying on to suggest that the court has already admitted the matter and therefore the trial court should not proceed. This is an order of 22/5/25. Heard so-and-so learned counsel assisted by so-and-so learned counsel of the petitioner who has pressed for admission of this application under 227 of the Constitution of India. The learned senior counsel has submitted the prayer is essentially aggrieved. The petitioner is essentially aggrieved by an order dated so-and-so passed by the Court of Assistant District Judge, Shillong in Miss Case number so-and-so arising out of title execution case, wherein paras 6 and 7 of the said order has been pointed out to say that the trial court having issued a decree and execution of the same being duly ordered in course of time, another execution order was passed in the self-same decree which is impermissible in law. Being thus aggrieved, the petitioner has approached this court for adjudication of the matter. Learned counsel has accepted notice on behalf of the sole respondent and has no objection to the admission of this petition. He, however, prays that this matter may be finally heard and disposed of on the next date. Accordingly, on consideration of the submission made without going into the details of the merits of this petition, the court is prima facie satisfied that this petition is fit to be admitted. The same is accordingly admitted. There was no stay.
I'm not
Now,
saying
my
this
lords,
stay.
what I'm saying, the very fact that their application or their prayer for grant of stay was declined by this court, that acts as res judicata. The principles of res judicata stand attracted in this case. Now, what they are seeking to challenge before this court or seeking a stay of is a subsequent order. That is not under challenge in this revision application. If they are at all aggrieved on merit, they'll have to file a separate revision application. In the parent revision application, this order is not under challenge because it is subsequently passed. So therefore, this miscase for stay does not arise. There is no question of entertaining this application. And my lord,
Pass in a separate proceeding.
yes, my lord. The
Same
miscase,
proceedings,
no,
same
in the execution application, we had filed a miscase for certain directions. An order came to be passed. That order was challenged by way of a revision application, which is pending before this court. They had prayed for a stay. Stay was declined by these orders that I just pointed out. Subsequently, your lordships have allow the trial court to proceed in the matter in accordance with law, and accordingly the trial court has passed certain orders. Now that order is being put to challenge here. Not even challenge, they want a stay order. And what is the ground, my lord? That the senior counsel is not available. From 22/5 to 25, the lordships have seen not a single opportunity has been, every single time this matter has been listed, they've sought time. Right from 2024, they've never come forward for hearing of this matter. This is an unscrupulous litigant who's taking advantage of the system. No relief should be granted to him. Let the trial court proceed. Lordships will recall I had impressed upon my lords that in case they are successful in the revision application, they are entitled to restitution. They'll be put back into the premises. The premises is not going anywhere. So why are they avoiding the matter before the trial court? They never appear.
If I understand correctly, see, I may be mistaken.
Lordship.
The grievance is only with regard to certain articles of theirs,
Yes, that's all.
in the suit property, which was not handed over to them.
The property is now locked and the keys are in the possession of the court. I am not entitled to access this property. I am being deprived of this particular property. This is my property. I have already succeeded.
Where's the inventory?
The trial court has already prepared the inventory. He's got a few cars and some other articles lying in this property. We just want to remove it and we want access to this property. He does not pay rent from 2017. There is no rent. Why should I be deprived of the fruits of the decree? From 2013, the decree was passed. We are in 2025, my lord. It's a shocking situation.
So the property is lying, under lock and key.
Yes.
In their possession.
Symbolic possession. I just have the
Decree
key.
has
It's
been
sealed.
executed.
It's sealed by the court.
My lord, the interesting thing here is, my lord, once the decree is already executed, in the same proceedings, my lord, another order
Since
has been
my
passed.
friend is ready, we can argue the matter right now.
No,
That's the problem.
My
He'll post it to
I've
22nd.
been very, very honest. over
22nd,
there,
the
my
senior counsel again be on leave. There
But
are
we-
two
we-
senior
we sit
counsels
on
who are on
22nd,
board.
my lord.
My lord, there are two senior counsels who are on board in this particular case. Today, my friend is on board. Nobody is willing to argue this case. It is just an attempt to try and avoid hearing of this case. That's all.
I'm only praying till the 22nd, my lord. If the matter is not heard on the 22nd, my lord, if I'm asked to argue on the 22nd, I'll argue. Well, what is the case over here? Once the decree has already been executed, in the same proceeding, another order has been passed. That is what has been challenged over here, and lordship has found some merit in the civil revision petition. Now, if this order is allowed to go today, my lord, nothing remains, and I'm only asking for 1 week's time. If my learned friend has waited to avail the fruits of his litigation for more than 2 decades, my lord, 7 days will not. I don't think so. It will be a very long.
I've
window
not
of
waited,
time.
my lords. I've not waited. I've been forced to wait. And my lords, those orders that lordships have passed have not been challenged. They've attained finality. So where is the question? They have to show me a way out. Some judicial precedent which allows them to avail this sort of a stay order from this court.
My lord,
It's not just for the sake of
order-
asking. It's
my
not
lord,
just for the sake of asking we file a petition and get a stay.
Lordship will
Is it
see
under
page-
challenge in the revision application?
Page
No.
22, my lord.
when is this,
This case number 47 is under challenge
When is the main case listed?
on 22nd, my lord. Just next week. Just next week, right after Diwali, my lord.
Okay.
And the order is passed in the same miscellaneous application.
We might as well hear the.
Yes, my lord.
No,
will
I'm
finish it
ready.
up.
Let it be heard tomorrow. Why 22nd?
I-
Let it be heard tomorrow.
Lordship, the difficulty.
Nothing is happening immediately. Nothing is happening to the property immediately. I have serious urgency. Well, the Supreme Court has directed it should dispose of within 6 months. I filed this application in 2017. We're in 2025. If lordships go through the entire order sheet, lordships will be shocked at the manner in which they've dealt with this case. They've taken the courts for a ride. Absolutely unscrupulous litigant. He's not entitled to any kind of equitable relief from this court. I would implore my lords, please go through the records to see what he has done.
Lordship,
Every single date before the trial court, on some pretext or the other, they take an adjournment. How many relatives have been killed? It's unimaginable.
Your relative.
Nobody is left now.
my lords, I'm here today only on this case.
He's had every single ailment in the book. So,
But a very serious question of law is under challenge. Well, that is what I've understood. My lord, I'm only here today for the miss case.
so my friend is well acquainted with the facts.
So that is why, my lord, the matter is fixed on the 22nd. A very short accommodation. My learned friend will understand. My lord, senior counsel is unwell.
No, no, the question of stay does not arise. I would seriously oppose
So
it.
let us keep this in for an
is a
abeyance,
question
my
of
lord,
law.
till the next day.
Question of law.
We'll pose this matter for final hearing.
Well, then let this order be an abeyance, my lord. Otherwise, nothing
No,
remains.
question of state does not arise, my lord. I would seriously oppose it.
Well, kindly see if this
Legally,
order
how is
given
it
effect to, my
permissible?
lord.
How is it legally permissible?
We
It's not
have
even under
challenged.
challenge.
We have challenged the order passed in case number 49 earlier. Same order has been passed in the same similar order has been passed.
My lords, in the previous orders that lordships had passed, I had impressed upon my lords the provisions of section 144 CPC. If they succeed in the parent revision application, they are entitled to restitution. That's all. That is the remedy. Nothing else. And if at all they want to say, let them go for the trial court, make a prayer. Why before this court? That order is not under challenge here.
My lord, order has been passed in the same miscellaneous application. In fact, this order should not have been passed.
I fail to understand how they
Same
make these
order has been
submissions.
passed.
Exactly. They have to renew the entire purpose of getting the property back. So, according to my friend, endlessly they should be entitled to keep that property under lock and key.
No,
Well, there are two parts of the decree. May I just also explain to Lordships what are the two parts of the decree. First part of the decree is a monetary decree where he was directed to pay arrears of rent and damages. That's to the tune of about 50-60 lakhs. Till today, he has not paid the amount.
See, Mr. Gautam,
My lords.
I don't think there's any issue of stay of this order. The fact being that, look at the operative portion. It says fix 1410 for report.
It's today.
Only
my
for a
lord.
report, that's all.
And
Nothing further is happening.
no, report is on what the bailiff has done. Whether he has taken out the goods from the
No, the bailiff did not even go to the property to take out the goods because he said he is in Chennai for treatment. How has he filed his miscase? God knows. Whenever a miscase or something has to be filed, he suddenly miraculously appears before the court. He's in Shillong. Whenever the case is listed before the trial court, he disappears. A relative dies, he comes up with a very serious ailment. Every single trick in the book, my lord. Every single trick in the book. I'll take your lordships to the entire order sheet.
My lord, I may not be guilty of all the tricks which my learned friend is talking about. I am here only today for the miscase. Only pray is, my lord, let this matter come on the 22nd for final adjudication.
I can post fix the matter for, take up
This
the
order
matter.
may be kept
My
in
lord,
abeyance.
may
This will be a
prepone the
hurdle,
case.
It's a
my lord.
question of keeping in abeyance this order because it's only
My lord.
it is only it has already been taken action. When the report is supposed to be filed today,
Today only a report is being filed. There is no course. It's not that the court is going and taking out
the
the
report says
belongings.
yes or no, then then the next course of action will happen.
Lordship, absolutely. My lords, I am saying let this be preponed. I have no difficulty. Have it tomorrow, day after, any day. But that's the problem.
It's
The
on the
council doesn't want to
22nd.
argue.
We'll
the
have
case.
it on 22nd.
Lordship understands the
No-
senior counsel is unwell.
No further adjournment. Senior counsel unwell. Let plaintiff or rather let the petitioner make alternative arrangement.
My lord, my lord.
You are there, Mr. Gautam.
My lord, my lord.
Or Mr. K.C.H. Gautam, learned counsel for the applicant who has submitted that there is a pending litigation before this court between the parties, the same being CRP number 9 of 2024 concerning a suit property and the execution process suit property, a degree passed as regard the suit involving the said property, suit property involving the property and the execution proceeding following such degree. The petitioner being aggrieved with the procedure carried out by the trial court and execution court has approached this court with relevant prayer. It is, however, the learned counsel has, however, submitted that pending disposal of the said CRP 9 of 2024, the trial court in the entitled execution number 2 under bracket H of 2017 passed an order dated 23/9/2025 in Miss Case number 49 H of 2023 directing for execution of the said decree. It is the submission of the London Council that if the impugned order is allowed to proceed, the whole purpose of the prayer made by the applicant as petitioner in the said CRP number 9 of 2024 would become futile, and in fact the petition itself would become infructuous. It is therefore prayed that relevant records be called for, and in the meantime the said impugned order dated 23/9/2025 be stayed. Per contra, Mr. S. N. Leonard, counsel for the opposite party, has strongly objected to the prayer made and has submitted that the course of action taken up by the trial court has been carried out with due deference to the various orders passed by this court, wherein there is practically no stay for execution of the said decree. Be that as it may, the Learned Council has also imputed delinquent conduct as far as the applicant public petitioner is concerned, to say that throughout these proceedings he has made several attempts to stall the hearing of the petition. As such, no concession may be given to the applicant, and rather the main petition may be taken up for hearing at the earliest. This court, on consideration of the submission made, without going to the merits of the matter, on a cursory glance at the impugned order, what is noticed is that the order was passed on 23/9/2025, whereby the bailiff was directed to remove all the goods and articles belonging to the judgment data public applicant herein from the suit premises. Incidentally, the date fixed for filing of report by the bailiff is today, that is 14/10/2025. On record, this court is not aware of any report file nor the contents of such report is also known. In such a situation, to stay the operation of the said impugn order may not be practical. Whatever the outcome, the parties are entitled to resort to legal remedies if so desired. However, on prayer made by the Land Council of the parties, I think that's all. Accordingly, this petition is found devoid of merit. The same is hereby dismissed as such. Petition disposed of. So 22nd.
Item number 2.
Please, Your Lordship. Lordship, I kindly pray if this matter may be taken up at the end of the vote, Your Lordship, as the leading counsel is on legs, Your Lordship.
Daily list item number 1.
Please, Your Lordship. Lordship, here the respondent, Your Lordship, they have filed an objection to the grant of leave, Your Lordship, by way of an affidavit, Your Lordship. On that,
The final objection now, my lord. Matter come for hearing, my lord, after week.
Objection for. This is a
Leave to file appeal against acquittal, my lord.
okay, against acquittal.
My lord. The CBI matter they have been acquitted, my lord.
But why objection?
They filed objection, my lord.
they have filed for
The
grant
time
of
was
leave.
granted by the court, my lord, the court.
So what do you do?
I'll just go through it, my lord. Next week or after 2 weeks.
You have all the respondents.
Yes, Your Lordship.
Excuse me. Miss Learner Counsel for the respondent has submitted that the objection to the filing of this
Application for leave.
application for
Leave to appeal.
leave to appeal has been filed, to which Dr. Edmoziga Leonard DSGI has sought for time to respond to the same. Accordingly, as prayed for, the objection, the response to be filed is the response is to be filed within the next date fixed, after which the matter will be heard. How long?
2 weeks. 2 weeks.
This is matter of 2 weeks.
My
Item number 2.
Your Lordship, I have taken steps upon the respondent, Your Lordship. Service is still awaited.
So we wait then,
Yes, Your Lordship.
Mr. Learner Counsel for the applicant has submitted that the notice that the report on the notice issued upon respondent has not yet been received. It is prayed that some more time may be allowed for the said report to be filed. As prayed for, the same is allowed. Dismiss matter after 3 weeks.
Item number 3.
Lordship, I have filed my power for the remaining respondents. Respondent number 7, 9, 10 and 11.
All the respondents have
Yes, I'm
received
representing
notice?
all the respondents, Your Lordship.
your respondent.
1, 2, and 3.
1, 2 and 3 KCDC.
There are 12 respondents.
Yes, Your Lordship. In total, 12 respondents.
So you
From
are
4 to 12. From number 4 to number 12.
Your Lordship, as far as the respondents 1, 2 and 3 are concerned, being the District Council, time and again has been slotted for them to file their counter affidavit. Your Lordship, I will pray that this may be the last chance that is granted to them to file the same.
Lordship, I pray for 3 weeks' time to file my affidavit.
they have not. They have also
No,
not
for
yet filed.
respondents 1, 2 and 3, Your Lordship.
See, when the matter is heard, it will be heard at the same time when all the pleadings are in place.
Yes.
Certainly, Your Lordship.
You have not yet filed your counter.
Will be filed.
Do it. Mr. Learned Counsel for the Learned Counsel has submitted that he is appearing on behalf of the respondents 4 to 12 and has sought for some time to file the counter affidavit. Similarly, Mr. Learned Counsel appearing for the respondent 1 to 3 KHADC has also sought for time to file the counter affidavit. Mr. Learned Counsel appears for the petitioner. As prayed for, the counter affidavit is to be filed within the next date fix. This is matter after 3 weeks.
Hello, Raj.
Item number 7.
Well, this is the first thing your Lordship will have to decide, my Lord. These are part and matters. Number of cases it happened because of the change of the roster. Well, I'm just submitting on the law, your Lordships. Now, 58, my Lordships, 58 of the High Court rules. The procedures are governed by, my Lord, the High Court rule. 58 very categorically state, your Lordships, that tied up matter has to be listed before the same judge. Now, my Lord, no doubt, my Lord, it is the, my Lord, Chief Justice, whoever is the Chief Justice, my Lord, his prerogative to change the roster. Now, my Lord, there are certain High Courts, my Lord. For example, I have come across on the Madras High Court. Now, Madras High Court, they have a rules in their High Court rules which say if the roster is changed, then nothing will remain pardoned. So, by operation of law, my Lord, we need not argue. By operation of law, even the pardon matter get transferred, like in Madras High Court. So, for our High Court is concerned, there is no such provision. Then, if the roster is changed, then the pardon matter will cease to be a pardon matter. Instead, it very specifically, my Lord, say, if I can just read out, my Lord, short provision. Which one? 58. Pardon matters, my Lord. High Court rules, my Lord. Page 36, my Lord.
Page 36
36, my Lord.
is part heard matters, yes.
Part heard matter. If I just read, a case which is part heard shall, unless otherwise ordered, there has to be a specific order, my Lord, by a bench, be placed first in the daily cause list or weekly hearing cause list for the day in which the bench which has partly heard such case next sits for disposal of the case. There are two conditions, your Lordship. What it say? If it is a part heard, has to be listed before this, unless there is a specific order. That means, my Lord,
If it is release or something like that,
exactly, your Lordship. Release, sometimes it happens, my Lord. For example, I come across some decisions, your Lordship. Even if it is before a single judge, sometimes, my Lord, it's a prerogative of the Chief Justice, considering the, my Lord, nature of issue involved. He may refer it to a division bench. That kind of situation. Here, nothing like this, my Lord. Hearing concluded, Lordship will see the order dated, my Lord. Order dated 1/8/2025. Only some clarification I was supposed to place. 1/8/2025. that judgment. Paragraph. Paragraph 7. Where is paragraph?
Yes.
Well, that is a part on my lord. Almost concluded, your lordships. And next order also, my lord, 19.825. Lordship will see. Just give me And now, my lord, I came across a judgment also, just to clarify my other things. My lord, I think it is a mistake of the, my lord, registry. They should have looked into it, my lord, and placed it before the same. But anyway, my lord, I'm just relying on judgments.
You can't expect the registry to go through each and every order of the case.
Normally, what happened, my lord, when we started our practice, nowadays it's not like this. Whenever a matter is heard, lordship, partly heard, then on the top of the file, my lord, the registry used to write part heard matter. And part heard matter always, my lord, on the next hearing would be listed on the top. But somehow, my lord, we have come out.
More often
That make things easy for the registry also.
You see, more often than not, parties expect, or even the court would see that, in course of the order, the last line would say, this matter is kept as part heard.
Normally. But then
Normally we do that.
Once it happened to me, before a division bench, I was arguing the matter. Then, my lord, matter was substantially heard. Then, my lord, I just made a prayer, lordship will make it part heard matter. The court reacted, my lord, what is there? I have heard the matter for further hearing. Is it necessary I should write? But here also, my lord, same thing. Lordship will see whether the matter was heard, whether the court was in the middle of the hearing. Court was in the middle of the hearing.
No, that is the practical aspect of it.
Yes, yes. And another thing, your lordships, just one judgment, my lord, paragraph 7. I have supplied a copy, your lordships. 2018 1 SSC 196. The Supreme Court dealt with this issue. Paragraph 7. The aforesaid position, though stated as regards High Court, we are absolutely certain that the said principle applicable to the Supreme Court. We are disposed to think so. Unless such a position is clearly stated, there will be utter confusion. Be it noted, this has also been the convention of this court, and the convention has been so because of the law. We have to make it clear, without any kind of hesitation, that convention is followed because of the principles of law and because judicial discipline and decorum. Once the Chief Justice stated to be the master of the roster, he alone has the prerogative to constitute benches. Needless to say, neither two-judge bench nor three-judge bench can allocate the matter to themselves or direct the composition or constitution. To elaborate, there cannot be any direction by the Chief Justice of India as to who shall be sitting on the bench and who shall take up the matter as that touches the composition, the bench. We therefore, such an order cannot be passed. It is not continuous with this. More relevant to your lordship. This is
what does it mean?
My lord, I
This
think
means nothing.
Lordship, my lord, 1998. Para 19. Well, that is more clear. Para 19. My lord.
Yes.
Para 9, that's very clear. My lord. There is also Supreme Court judgment. Under Rule 74, similar like 58, my lord, in Rajasthan High Court, case which remain part heard at the end of the day is ordinarily required to be heard by the judge concerned or the judge sitting next, and is to be placed first after miscellaneous cases in the next list. But that does not imply that the Chief Justice does not have the power or jurisdiction to transfer even a part heard case. Next line, my lord, very well. In peculiar facts and circumstances of the case from a single judge to a division bench. Even if there is a change of roster, my lord, is the master. But if part heard matter is transferred, my lord, there has to be a specific order. Lordship will look into that administrative order. This is only, my lord, change of roster. That particular year would be heard by my lords. There is no reference of releasing any part heard matter. So my humble submission, my lord, this matter needs to be, my lord, placed before the judge, my lord, who heard the matter. This-
But as you have rightly, you see, you have read the other order. See, this court cannot do so. Once a matter has been, allotted to this bench, it cannot just, on a whim, just release the same, just because it was part heard.
Then what will happen, my lord? How will
And
negotiate
it's-
Rule 58? Rule 58, my lord, then we are violating our High Court rules. What will happen? 58 says it has to be before the same judge. And my lord, the business of the courts are conducted by the High Court rules. Para?
Because at the end of the day, it is the prerogative of the
Chief Justice.
Chief Justice.
Allocation of work. But not part heard, there has to be a separate order. In this case, there is no separate order, my lord, releasing it from part heard. Either it has to be there, or there could be provision in the High Court rules which say if the roster is changed, then any part heard matter will cease to be a part heard matter. There is nothing like this in our High Court. How High Court rules say, my lord, tied up matter has to be listed before the same judge. So, my lord, if your lordships, my lord, if it is not,
We'll
my
do one thing. We'll adjourn this matter.
wait,
Adjourn this matter for 1 week, and then we'll see.
And my lord, this 2015 SSC online also, my lord, very clearly say paragraph 79. Lordship will come. Next page, my lord, on the reverse side. Paragraph, my lord, they have quoted 79. Next page. First page and the next page, my lord, on the reverse side. Lordship. In view of the above, part heard and tied up cases should be listed before the same bench for disposal. Listing of part heard and tied up cases to other benches is an exception. Accordingly, in case Honorable Chief Justice is of the opinion that the particular case is to be listed before the bench for fresh hearing, then necessarily it implies that the part heard and tied up matter is an exception which requires separate order. That's what, my lord, I am harping on. If it is to be released, my lord, if it has been transferred, tied up cases also, there has to be specific order. There is no such order, your lordships. A number of cases, my lord, not one, I think. So far I am concerned, my lord, as a lawyer, my lord, I have concluded my hearing, my lord, substantially, my lord, before Honorable Justice. Thank you. And my lord, ultimately, administrative work came, my lord, changing the roster. It doesn't mean, my lord, tied up matter, because I have checked the list. He has not released. He has to go back, my lord. Because if we are not, my lord, how will negotiate 58? That's my submission.
Correct, but we have already advanced our argument already before the quarter number 2. Only
Not for any other thing.
regarding certain aspects.
We feel
what was
privileged to do it
certain.
before your law. But this is the situation, my lord. 58 comes on the way. And not only this, my lord, 3-4 cases. I don't know for other lawyers, maybe. But
Yes, I mean, some of them are facing the same problem. But
unless it is released, my lord, what is necessary? Administrative order plus tied up matter transfer, specific order. For certain reason, even those has been released. There is no such order. My humble submissions, my lord.
okay.
If your lordship, my lord, take a decision on this, then there are other, my lord, 3-4 cases. So far, I am concerned, my lord.
No judicial order will be passed as yet. Let me discuss the matter with the.
Yes, whatever, my lord. I think, my lord.
There may be an administrative
No,
order
what I
passed
have apprised, my lord,
Yeah.
the position of law. The position of law. Lordship.
on pre-made by parties. This is matter after 1 week.
Lordship. Oblige.
Item number 10.
Tigi judgment sa ay sa mo sa kumrasti.
My lord, in this case, my lord, I have been convicted under section 304, my lord. The item number 10 and 11, these are connected matters, my lord. So I will like to address my lord in the item number 10, and that will also, the points will cover for the item number 11 as well, my lord. Before I take my lord to the depositions and statements, my lord, there has been a serious miscarriage of justice in convicting my clients under section 304, my lord. And why I say so is, number one, this conviction is based only on TIP, my lord. There is no supporting substantive evidence, my lord. And even the prosecution witnesses, my lord, who are supposed to be the main witnesses, my lord.
How long will it take? Sir,
Second half, my lord.
We are already.
We continue second half, my lord.
So we'll take it up in second half.
Second half, my lord. Obliged.
Item number 12.
Item
12 is a very short matter, my lord. This was with regard to the district council check gate, my lord. The 144 order, my lord. Now law is very clear, my lord, that order could be operative only for 2 months' time. 2 months already over, my lord.
Let the matter be heard, your lordship, because we have question. The state has questioned the power of the district council to set up a tollgate, your lordship. That also on the national highway.
My lord, that they can do it somewhere else, my lord. But here the order has been issued under 144 CRPC, my lord, 163 BNSS.
Lordship,
And that order has become, that has expired, my lord.
In the prayer,
no one can revive that order, my lord.
In the prayer, lordship, they have been an alternative. Let the matter be heard, lordship. If the matter comes tomorrow,
There's an alternative prayer.
yes, your lordship. Let it come tomorrow, your lordship.
No, so that was simply to set aside that order, my lord. BNSS. So because that time it was valid, now it is expired, my lord.
Yes, of course. You see, if you look at the legality of it, the impugn notification has begun process.
It is expired.
But, lordship, we have questioned the source of power of the district council. Under which authority of law, your lordship?
Under 163, my lord. 163 order is expired. So I only
because
want
the admitted fact is that, your lordship, the gate has been closed down, your lordship. Now, your lordship, they'll go back, they'll reopen it, your lordship.
Yes, definitely will reopen it.
Because that power, your lordship, since I have submitted, your lordship, that we have questioned the power of the district council, that has to be determined.
While closing down their gate, why have you resort to 163? That's an if I can understand correctly, that power is used only
even there is also
only in emergency situation, only when there's any likelihood of a law and order situation.
Lordship,
my lord, such check gates have been upheld by this honorable court just to circumvent that order, my lord. They are resorting to 163 BNS.
No, your lordship.
Even that cannot be permitted.
That order which they have relied heavily also, that liberty also has been given. We can question the source of power of the district council to set up the tollgate, your lordship.
That they'll do by 144, my lord. That is.
Let the matter be heard, your lordship. Let the matter be heard, your lordship.
We'll hear the matter.
Lordship, yes.
Tomorrow day is a very short matter now, my lord.
You say short, he say long.
It's not short, your lord.
Long and short, 10-15 minutes, my lord.
So we'll go into the long and short of it.
Not come in the middle, your lord. No, after a week, your lordship. After a week.
But district council has no role, man. District council has filed affidavit.
Lordship,
they're supporting my case.
They'll have to answer. They'll have to repel my argument, your lordship.
No, I am the petitioner. Why? It is my case. They are respondents, my lord. Why he has to repel his argument?
They'll have to repel my argument, your lordship.
Well, kindly not 2 weeks.
Under the national highway.
Maybe.
It's admittedly, your lordship, it is on the national highway, whether they have the permission, your lordship.
Order doesn't say they cannot improve anything, madam.
And there is also a recent judgment of the Honorable Supreme Court, your lordship, directing the government of India to remove all encroachment. That also I'll place before your lordship.
There is not even encroachment, madam. They can't improve. They can't improve their case now, madam.
I'm praying that the matter be heard, your lordship, and
next week,
the issue be determined
next week.
finally, your lordship.
Next week, then. On pre-made by the parties, let's this matter after 1 week.
Obliged.
But before lordship, I have a small prayer, my lord. Item number 2 has been passed over, my lord. But here, what happened, my lord? We have come against cancellation of bail by the trial court, my lord. Now here, because we could not obtain the certified copy, my lord. So we have filed a miss case for exemption from filing certified copy along with the revision, but revision record has not come, my lord. Your lordship, by the lunchtime the records can be called for, my lord.
Revision.
My lord. Only the miss case as the records are here what it appears, my lord. Miss case number 100, 120. The record of revision petition number 6 has not come. The record that can be called for. After lunch, in the meantime, they can bring the record.
There's another matter, no, that hearing.
This revision petition is pending before this court.
Yes, my lord. We filed. What happened, my lord? It's a fresh matter, my lord. It is a fresh matter. The trial court has cancelled the anticipatory bail granted, my lord. Against that, we've come. So because a very short time, my lord, court has directed us to surrender within 1 week.
Okay.
And because Saturday Sundays, we filed an application for exempting us from filing the certified copy of the order, my lord. So only that miss case has been listed. The revision has not been listed, my lord. If only the direction to call for the records, my lord.
Or the revision has not been admitted.
It's not listed today, my lord, the revision matter. So let it come up tomorrow, lordship.
Not listed today.
It's not listed today. It's just a miss case today.
Well, only because it is not nothing like condonation of delay, my lord. Condonation of delay, delay has to be condoned.
Yes,
this is simply for exemption from filing certified copy, my
So
lord.
let the matter come up tomorrow, my lord.
This, you're talking about what revision petition you're talking about?
My lord, what happened, my lord? Nongpo court has cancelled the anticipatory bail granted, my lord. So against that, the remedy is only by filing a revision application before this. Now we could not obtain a certified copy of the trial court's order, my lord. So we filed a separate application for exempting us from filing the certified copy, my lord. So only that application has been brought on record, and only that has been listed, my lord. The main revision has not been listed, my lord.
It's not listed today, lordship.
Is this the one? Not this one?
I think that is miss case number 120 only. It's here. It's here, my lord.
But it's not listed today, lordship.
Not listed. No, because it's not because not yet admitted.
Exactly, my lord.
So, but it's tied up, with the
So, my lord, after lunch, my lord, after that.
My lord, if it can be listed tomorrow, lordship, we'll come up with a status report also, my lord.
Have you filed the copy of the order?
Yes. Downloaded copy is there, my lord.
Downloaded. You just check and see if that is good enough. The downloaded copy.
Yes, 111 page is there, my lord. Download copy is there.
Right. So tomorrow?
Tomorrow, my lord. Much obliged,
Only because the direction is to surrender within 1 week. So 1 week is expiring today.
When?
Expired yesterday, in fact. We filed this on Friday, my lord. That's only.
It's already expired, lordship.
No, we filed before expiry, my lord. Because bench was not available.
True.
We tried to mention before the other court didn't entertain the mentioning also.
But urgent matters you could have taken up. Anyway, that's beside the point. We'll take it up tomorrow then.
Much obliged, lordship.
Well.
As prayed for by the parties, let's this matter tomorrow.
Blind. I accepted your request. You have to accept my request also tomorrow.
My sugar's high right now. I'm just waiting for you.
So, my lord, before we rise for the,
Has this matter been heard?
it was heard, my lord.
Finally heard.
It was heard, but the respondents were yet to reply. But I will not go into that rules, my lord.
Because I'm
Yes.
now. I'm thinking,
Yes, yes.
My lord,
that is
on
the
the previous matter, my lord.
Yes.
That is the situation. No, I don't
Yes.
know what we'll do.
Yes, my lord. But my lord, may I pray, my lord, kindly take up this matter because I'm not going to raise because thinking, my lord, because that will just
Question is on
delay.
the part heard, my lord. On the last item, my lord had already indicated that it will take a week time to take a call on that. So, my lord, it will look bad if in one case, similar situation, my lord, it is posted after a week and the other case is taken up, my lord. The parity won't be there, my lord. It's heard. In fact, written submission also has been filed by. Yeah.
By me only, my lord, but not by the respondents, my lord. But
So
my lord,
means
the trouble is mine. Trouble is mine. So, my lord, I am
The
just
lordship will take
yes.
up, my lord.
Because I'm only concerned about the delay being caused, my lord. I understand the integrities of the rules, my lord. It is there, but I am not raising that rules, my lord. But since the matter has come before my lord, now it's up to my lord to because it has already been the roster has been changed and it has come to my lord already, my lord. Maybe through oversight it must have come. That will not go into that because in the administrative part, my lords are going to take a call on that, my lord. But then, my lord, what I would insist is because, my lord, this matter, my lord, pertains, as I said, my lord, there's a, my lord knows very well that you cannot convict somebody only based on a TIP, my lord.
We are not into the merit
Yeah,
right now.
no, no.
When lordship will decide on whether it matter will be
That's
taken
the
up.
reason why I'm saying, my lord, further prolonging this petition, my lord, it's only causing a prejudice to my client, my lord. Now, this I can show, my lord, this is solely based on a TIP. And also, my lord, what they say, they've got two star witnesses. My lord. These 2 star witnesses are the interested witnesses, my lord. And when the question of interested witnesses comes, then it has to be scrutinized very cautiously, and you have to see a corroboration. Nothing as such, my lord. Nothing as such. Just because it says that there is a group fight. There are group fight. In this group fight, this person sustained injury, succumbed to his injury later on, and in the TIP, he said, "Oh yes, I saw these people in the group." That's the only thing, my lord. That's not enough to convict. And very importantly, my lord, the Supreme Court has held again and again, my lord, when you do a TIP, my lord, the magistrate has to be there. There is a process of doing a TIP. TIP is not a corroborative, it's not a substantive evidence, but the manner in which it has to be done, there are prescribed rules to do that, my lord. Now, the magistrate who's conducted the TIP was never examined, my lord. The case fails that's itself in this ground, my lord. If my learned senior wants this matter to be adjourned, my lord, on this ground, may I pray, my lord, because my bail already is pending. There is no bar for my lord to consider my bail.
No,
Interim, maybe 1 week, 2 weeks.
The qualifying, my lord, margin, serving of sentence has not reached to that point, man.
No, that I'm not on that point. I'm not on a 50% period you have served.
I don't have any
70%.
issue, my lord. Lordship takes up the matter, my lord. I don't have any issues, my lord. But the fact remains, my lord had already passed an order. That's why.
It will not be proper for me to.
But my lord, then my lord may consider my bail because my bail application also is listed today, my lord. I'll just show 2 grounds, my lord.
No, even then that would be.
That is a part of the, my lord.
That would be taking cognizance
part
of
of the
matter.
appeal, my lord.
My lord, because
Can we do one thing, Mr. Lubin?
my lord. Because now, my lord, if my lord is adjourning the matter,
Can we take up on 22nd?
22nd, that would be immediately after the vacation. After the vacation.
I was thinking Friday, but Friday may be too short.
Too short, my lord, for my lords to decide. My lord, 22nd. By then.
You see, I have to take it up, on a personal level.
Yes, my lord.
So,
yes.
I may not be able to convince.
Exactly, my lord.
And personally, I have to be clear on this. Otherwise,
yes.
It should not be a case to case, my lord. There should be a parity on it.
Well, the rules, what the nurse senior, Mr. Sen has submitted in the morning, I was there.
But
He's very much right, my lord.
True, but you see, in matters of those, like his case where, argument from both sides.
Yes,
only
here
50%
argument is not complete.
So, but
Part-heard.
according to
It
me,
comes under part-heard.
part-heard matters, it's always there in the order sheet.
My lord. Yes, it is there.
This
my
matter
lord.
is kept as
Yes.
part-heard.
Yes.
That was the old practice, my lord.
But then
Suddenly that is...
the practical or
Yes,
the reality is that some matters are really indeed part-heard,
Yes, my lord.
but not necessarily noted down.
Unlike other matters, High Court rules, my lord, we are silent on that matter. That also has to be looked into.
No, High Court rules is very clear. He has pointed out that rule.
Yes,
58.
exactly.
But that is, you see, that is universally accepted.
Accept.
Every High Court will have that rule.
Yes, correct.
If part-heard matters are concerned.
Correct, my lord.
Even, for example, even in DB,
Yes.
when I sit with Justice Sankey,
Yes.
some matters are kept part-heard.
Yes.
So when the new dispensation comes, those matters still
Remains
retained by
with the
that
bench. Yes.
So because of a specific,
Even if it is transferred, my lord, some specific orders and reasons has to be cited, my lord.
that is a different aspect.
Yes. So, my lord, because I am only concerned about because I have gone through, my lord. My lord has seen. I've never insisted when parties are not. But in this case, my lord, I've seen that there's nothing. There's sustained.
Only on you see that.
My lord.
Another week won this thing, but just that, my lord.
See, Mr. on the lighter side, if your matter is being insisted on before Mr. Sen made his submission, then I would have.
That's my.
I would have been oblivious to what will come later.
That is the reason I try to keep myself very quiet and then push my case through. Ultimately, my lord.
It looks like Mr. Guru was saying. It looks bad on me. See,
my lord.
In one matter, I'll say no. In one, I'll say yes.
Absolutely, my lord. Absolutely.
That's what I was trying to make
I
it
just want to
clear.
be clarified on this.
My lord. Yes, my lord.
If it is, you see, as far as courts are concerned, we have to take it up. We have to take matters up.
Exactly.
Whatever is placed before us.
My lord.
There is no. The only thing is that we are concerned about the parties.
Exactly.
What the like you rightly said. See, the trouble they face.
My lord.
Exactly.
So, as far as that is concerned, we'll have to think about it.
Absolutely, man.
But suppose now, if the rule says otherwise,
yes.
There's if it insists on a specific noting in the order sheet, then once release means release.
Yes.
Or once a roster change means it's change.
Yes.
So we'll have to look at all those aspects.
Exactly, man.
I'll see.
We'll have it on 22nd.
22nd.
My lord.
Deeply obliged, man.
I feel bad also. What to do?
It's okay, my lord. We'll have to wait.
On premeditated parties, this is matter on 22nd.
10 seconds, my lord.
Deeply obliged.